Welcome to All Things Moore County, Moore County's weekly radio show highlighting the many facets of the Sandhills. That includes real estate, lifestyle, community and neighborhoods. And now, from 4 Properties, here's your host, Bill Sahadi.
Good morning and welcome to the talk show, All Things Moore County. We have a very timely show today. It's a topic we covered maybe about 9 or 10 years ago.
Yeah, it's been a while.
Hard to believe.
Yeah.
I am being joined today by attorneys Patricia Niebauer and Bill Pate from Robbins May Rich, and a friend of mine, Mino Gironda, who is a local businessman who has 2 children, ages 7 and 5. And the topic today are the basics of estate planning. Mina, when I was your age, I remember going to cocktail parties, and the topic of conversation at that time was people bragging about which mutual fund they had or which stocks they had. They weren't talking about wills. They weren't talking about power of attorneys and living wills and trusts. It's not something, I guess each decade as you proceed, things change, but some people, when you talk about estate planning, they think they're going to the dentist. And yet, so many things, there are so many things that are so important to so many people. Even though you're a generation behind me, you're light years ahead of where I was because I wasn't thinking about any of this at that time. And some people think, oh, I have a will, and that's it. And so they're done, and they're 40 years old. They have a will, and that's it. Well, it's way more complicated than that. Patricia, you're of the age where you're a generation behind me too, but you deal with people of all generations, don't you? It's not just people in their 60s, 70s as they advance in age.
That is correct, Bill. It used to be when I started practicing in this area 14 years ago, most of my clientele was retirees who lived in Pinehurst, and I think as we've seen Pinehurst and the Moore County area become younger,
right.
A lot of my clients now are my age or a little bit older or even younger, and they're coming saying, we want to be prepared.
14 years, she's been practicing law. She must have graduated law school when she was 17 or 18. Look at her. I mean, that's crazy. Bill, both of you have been attorneys for quite a few years. You've been with Robbins May Rich for 4, but you were with your father in Pinehurst.
I was before, yes.
Prior,
my father, Daniel Pate, and I practiced together for a good little while.
Right.
So it's my 20th overall year of practicing in this area, so it's been a long time.
What? How do you get clients in front of you? Do they find you, or are they being... like in my case, my financial planner and my accountant both said, you need to put yourself in front of them and start to execute some documents. Do they come in willingly, or do they come in dragging?
Maybe all of the above. Patricia can speak if her experience is any different, but typically it is word of mouth from a client I've done this for. They tell a neighbor, they tell a friend. Absolutely. We have a relationship with several area financial advisors and CPAs and tax preparers.
Right.
And many times they do advise clients to have this done. What I have found is most people, they don't ignore their finances. And so they're usually smart and wise to have their money well managed and their tax situation covered. But this is often the thing that they forget about or don't put to the forefront. So just getting folks to remind them to do it is very important.
Yeah. When you sit down, Patricia, with a client for the first time, the basic estate planning documents, are they different depending upon the age of the client in front of you?
No, not really. I mean, every client needs at least a basic set of documents, which would cover your will, your power of attorney for finances, your power of attorney for healthcare decisions, a living will, and sometimes you have a separate form called a HIPAA form to allow access to your medical records by the individuals that you've named. Now, we could add more complexity depending on the client's situation and what they want to achieve, but you at least need to have those basic documents.
You didn't mention trusts in there.
Yes, trust is definitely one of those documents, but it's not for everybody, and not everybody is interested in a trust.
So you have to really get to know your client, their philosophy, their aspirations, their family, their wishes, their motivations in order to get them at least started on a program?
That is correct, Bill. Actually, my favorite part of what I do is getting to know my clients, and I usually start my conversations with them saying, now tell me about your family. Tell me about what you want to do and what you want to happen for your spouse, for your children. Explain to me the family dynamics. How do the children get along?
Right.
And all that is very important in how I craft an estate document or estate plan for those clients.
You know, it's no small coincidence. Just this morning I was at an estate appraisal for a property where the sibling relationship is not that great. And they were out there doing an appraisal on the home of the mother who passed in October. And that was village appraisers, Liz Geary, who I think you know,
Yes.
and Frank Dean. And I always wonder, because we get involved in estates on our side of the business, how many people are properly prepared when things happen unexpectedly?
You know, that's part of why they come. I mean, there's several people who aren't. I mean, there's Patricia's probably done them as well. I mean, there's many estates where people die without a will, and that's intestate estate administration. We deal with it, but it is much, much smoother and cleaner and much more user-friendly when they do have a document in place. So just getting them to have this. And then one thing you just mentioned is, especially in those situations, and usually parents know, with siblings that maybe don't get along the best or there's some friction there, having planning documents in place makes that, oh my gosh, process immensely easier to deal with in all situations, but especially in ones where there's potentially some disgruntled siblings or beneficiaries.
And Bill, just to segue into your world, which is the real estate world,
Yep.
if siblings don't get along and parents haven't properly planned for the disposition of a home, it could be very contentious and it could be very difficult to sell the house, which could cause untold numbers of problems.
I can vouch for what you just said because I've been involved in both the good and the bad and the ugly. And you sit back and sometimes it makes you realize how good your own family was. You know, when I became an orphan, my sisters and my brother and I, we sat down and they put an Excel spreadsheet together and everybody said, no, you take this, no, you take whatever you want. You go. None of us were selfish, but that unfortunately is not always the reality. Mm-hmm. But if it's spelled out, people sort of march in tow the way they should.
Yes.
What happens when you have people come in for the first time? How organized are they with the information that they bring you, or how unorganized are they?
Usually, if they call ahead of time, we try to give them a sheet that says, can you please fill out your information? To me, what's more important, while it's important to know the size of their general estate for tax purposes, what's more important is what type of assets do you have? How are they held? Do you have them in your own name? Is it a joint asset with a spouse? Is it a retirement account? And that will drive the planning process. And so to me, if they come in with that sheet, that gives me the ability to see what they have and recommend certain paths. And I don't know if your experience is similar, Bill.
It is. The level of organization is across all over the map. I mean, it really just depends on the person. But through the process, one thing I heavily encourage clients to do, it's not a legal document. It's nothing that you need me to do for you. But I encourage them to put together, I call it like a financial roadmap of sorts, just a sheet. And for some clients, it is a balance sheet and they have money numbers on it. But at a minimum, just something that identifies where your accounts are, you know, what banks you use, who your financial advisor, your CPA, your attorney, because I've definitely administered estates where we knew none of that information, and it is very difficult. And so anything folks can do to leave a kind of breadcrumbs, so to speak, of where their assets are and how to find them is very, very beneficial in an estate process. And typically when they do this, they will do that part as well. But yeah, the more organized, and the other thing to that is I tell clients, letting them know where these documents are, because the documents are no good if you do them and throw them in the bottom of a desk drawer, nobody can find them. So doing documents, putting your financial identifier in there, and then telling people where they can find it if the emergency or death happens.
So Mino is a father of two. He, don't know your age, but I'm going to guess somewhere in your 30s.
41. Thanks,
come
Bill.
on. Is that right?
That's right.
Okay.
Bill's buttering me up.
Would your presentation to Mino initially be different than perhaps your presentation to somebody of my generation, based on where he is in his life and where somebody in an older generation would be in theirs?
You can go ahead first.
Probably somewhat different because he has young children to think about versus an older adult. Their kids are probably grown and the concerns are not the same. So with Mino, I would be talking about if you and your wife died while the kids were still young, who would be the guardian of the kids?
Precisely.
And who would manage the money? Because the person who takes care of them physically might not be the same person you want to take care of the money. And at what age would you be comfortable with the kids having access to that money versus somebody else managing it for them? And so we're talking about all those very, very real concerns, which I think is why most younger couples come to try to get their documents in order to make sure that things are done well for their children. Versus an older couple, their kids are grown, they kind of know the character of the kids, and they can decide whether the kids need help with managing money or if they're comfortable with just letting go and having the kids receive everything.
Do people come into you initially and just say, I need a will?
Yes, that typically is what I hear, and I'm like, okay, that's fantastic. That is one part. But as we mentioned earlier, what Patricia mentioned, those 5 base documents are really crucial. The will deals with the death, and the other ones, the powers of attorney for health care and finances, the living will and the HIPAA, I call them living estate planning documents. They help you while you're alive. And so it's those 4 that sometimes people aren't as familiar with. And so they come in, they know I need a will, and we're able to lead them to the total thing. And just to piggyback, as you mentioned, would our approach be different for the ages of clients? Patricia's correct. Yes, some of the nuances of the documents may change, but honestly, these 5 documents form the base of any plan. Whether a client's 18 or 80 or has $8 or 80 million, these 5 documents are still the base of that plan, and then we work forward from there. So in a lot of ways, we're still starting at the same place, and then just dig into the nuances or the particulars as needed based on age and assets.
So the will itself, just the will itself, covers what?
It covers what happens to your assets after your death and who's going to administer the process of getting those assets to the beneficiaries.
Okay. That could be a family member or it could be somebody outside of the family.
That is correct. Oftentimes you'll see it be a family member because usually those are the ones that people feel most comfortable with because as I tell people who are in a tizzy about who to name, I say you're not giving somebody a gift, you're giving them a job. And so
that's exactly right.
And so oftentimes a family member is the logical choice. And of course, when you choose an executor, North Carolina law says that that executor is entitled to compensation. And so that's also a consideration for people in terms of who they name and if it's one child or more than one child doing it together. That plays into it. And oftentimes there is no good family member, and then somebody like an attorney or a financial person or a bank can be the person to step in to serve.
I have one last question. Oh, you wanted to say, go ahead.
Good.
Okay, before we wind up the first set, because I knew this would go fast. So somebody that dies intestate without a will, what are the major problems that they have versus if they had a will? What are they looking at?
I would say the biggest problem, and sometimes it's not a problem, is the state of North Carolina tells them where their assets go. There are North Carolina statutes that dictate without a will, here's who gets your assets. It's not the state of North Carolina. A lot of times people hear, it's just going to escheat to the state. That doesn't happen. It does go to your family. But for a lot of people, it might not be wife, kids, parents, who they want to get those assets. And so that's the first thing. And then secondarily, it is immensely more easy to administer and settle a will than an intestate estate, because there's just various nuances of things that you can put into a will that makes the process cleaner and easier. And plus you choose, because also you don't get to choose who the executor is if you die intestacy. So it makes things easier, absolutely.
Okay. We're going to come back in the second set. We're speaking all about the basics of estate planning. Our guests are Patricia Niebauer and Bill Pate from Robbins May Rich. We could probably add 3 hours to the show and never get through all the information that we would need to get through. This is All Things Moore County. We'll be right back.
Makes me a little bit hesitant as the IRA.
Welcome back. We're back on All Things Moore County. Patricia Niebauer and Bill Pate, estate attorneys with Robbins May Rich, are our guests. There's a lot to cover in a short period of time. And we close the first set talking with Bill about dying without a will, intestate. But it's not that simple, because sometimes people have misunderstandings about if they're married, they think that a lot of their problems are automatically solved. That's not the case, is it, Patricia?
That is correct, Bill. Oftentimes, how you hold your assets matter. For example, if you are married, but some assets are just in one spouse's name and you die without a will, they don't automatically pass to the spouse. And so, having a will is very important, because it's not just if you're married, everything goes to your spouse, but the North Carolina intestacy statutes can give some assets to the children and even to parents, depending on whether you have children or not.
So some people would say, if you're married in North Carolina and you pass away, the wife inherits the house, because it's not the marital right in North Carolina?
It would depend. What ultimately
It
comes
would-
down to
that's
it is
an
the
attorney's-
title.
it would
The
depend.
Yeah, that's right. The title to the property. Yes, if husband and wife own a property together,
Right.
immediately when one dies, the survivor has title. But to Patricia's point, if it's not titled that way, the end result of not having a will can be a bit surprising for folks.
That's why when we're writing offers on homes, the closing attorney needs to understand are they spouses who are buying a home? Is it brother and sister? That's why we have to put in wife, so everyone kind of knows how the deed is going to be held. Some women don't like that. Why are you calling me? Why can't my name go first? But you never know. How often should wills be updated, especially if you're coming from where Mino is? Every 3-4 years, as life events change? How do you set that up?
I usually tell people, especially my younger clients, I want you to review these documents every few years and at least dust them off, read through them, and see if you think anything needs to be changed. I've had clients who've died with wills from the 1980s, and they're still perfectly valid. But oftentimes, there might be new regulations that come in play, or life circumstances could have changed. I mean, I've had clients whose relatives have died, and that would necessitate an update to the will.
What about people who move into North Carolina, they buy a retirement home, they change states, and they're now permanent residents of North Carolina?
Here's what I tell people with that. First of all, moving states does not mean that your prior documents, explode or become invalid by any means. You still have them. However, it is recommended that you update if you are moving your domicile to a new state. The recommendation is really, this is where you are. And so it is much, much easier for me to take a North Carolina will to the local clerk and do the probate process, because I know they're going to accept it. Not that I can't probate out-of-state wills. It just often requires additional steps and things to jump through that can be a bit cumbersome. So for ease of use, same thing with the powers of attorney or the healthcare power of attorney. I don't want the hospital interpreting Texas code statutes or what have you. It is just much cleaner to update it. But they are still valid. And worst case, if something happens and you only have the out-of-state will, we will do our absolute best to use it and make it work for you. But kind of with all of this, the whole point is to make things as seamless and user-friendly, and that's what updating to the state where you are would do.
Can you talk, both of you, about probate and what probate entails, what it is? Because I think some people have misunderstandings about it.
So
Patricia.
probate is the process of when you die going before the court to administer the estate. So usually when you die, assets that are in your individual name get frozen because you've died and they don't want anybody else putting their hands in it. So you have to go to the courthouse, submit the will, get an executor officially appointed by the court. They get issued what is known as letters testamentary if you die with a will. And then that person who's been appointed as the executor can go running around to collect all the assets, and they're required to submit certain filings to the court. And it's a process that can take a year or longer, depending on how complex the estate is. So that is what probate means. And I've always told my clients, North Carolina is actually a pretty nice state to die from a probate perspective. We're not in California. We're not in another state where it's very expensive and very long-winded, because sometimes you have to make an appointment months out in order to get an executor appointed. And at least here in Moore County, it used to be a lot more user-friendly. That being said, I feel that with the advance of online systems where now everything is being required to be filed online, it's getting a little bit more complex to walk through the probate process. It used to be a lot quicker, but it's pretty cumbersome sometimes.
And the only thing I will add, a lot of times when I hear people that clients are fearful of probate, North Carolina is not a state. Assets aren't frozen. We're not kept from assets or from the ability to sell houses or other properties. So it is definitely user friendly. One thing that Patricia's explanation of probate came to mind. A lot of client assets now never touch probate. I am seeing quite often that the value of that definitely in the last 10 years plus of clients' assets that aren't real estate are in IRAs, 401ks, potentially or life insurance. All of those assets have beneficiary designations. And so just want to point that out, because those are non-probate in the sense that we don't need our local courthouse or a will to tell me where that goes. Those assets go where I have designated as a beneficiary. It's a contract between the person and that company. And so quite a bit of wealth now passes not through probate, but through those beneficiary designations. So it is just as valuable that clients update and look at who's the beneficiary of my life insurance, my IRA, my 401k. Some annuities have the similar designations. Just because it is just as valuable as a will. In fact, if you named me as the beneficiary of your IRA in your will and put it in writing, I wouldn't get a dime of it, because it would only pay to who the beneficiary was named, even if it's in direct conflict to your plan. Where there's a risk that named beneficiary truly could be not what you want is if you've been divorced or remarried and you had old IRA 401ks, and if a prior spouse's name is on there, they will get it if it's not up to date. So just it came to mind when she was mentioning probate. There's a lot of non-probate, outside of probate assets and wealth that passes, and that's through those designations. And that's something people can do with their financial advisors, or even logging in online to their various accounts and checking beneficiary designations.
It's a lot to digest.
Yeah, but this is great information.
It is good
Yeah,
information.
really helpful.
What do people come to you when they put these estate planning documents together with the motivation that they want to limit their tax liability? Is that am I asking? I don't know if I'm asking the right question.
You are asking a good question. What people usually are asking me is, I don't want there to be inheritance tax,
Right.
or a death tax. Sometimes you hear it called. We are in a very fortunate environment right now. Gonna round it, but it's about $13 million per person can pass without any inheritance tax, and that's each person. So a husband and wife could have $26 million, pass it to their kids, there's no inheritance tax, which is really phenomenal. So that's usually what people are asking about. Now, that number fluctuates. It's subject to change and can change at any point at the whim of Congress, but it is much higher than it used to be. That number used to be much lower, and we absolutely spend a majority of our time trying to avoid estate tax, where with those high exemption amounts now, we don't have to do it. But yeah, being tax smart is definitely part of what we look at.
We haven't talked about trusts yet, and I want to talk about trusts, what their role is and why people should look, and the different types of trusts that there are and what the advantages are.
Sure.
In 25 seconds. No.
Yes. So clients come to me saying, I want a trust to avoid taxes. And again, as Bill was saying, trusts are not necessarily a tax avoidance issue, although they can be used to move assets out of your estate so that when you die, they are not included in your estate. So from that perspective, certain trusts, especially irrevocable trusts, can move assets from being taxed down the road. But the trusts that most people use, the revocable trusts, which you can change during your lifetime, the primary purpose is to avoid probate.
Okay.
So, and I don't know if we have a little bit more time in
We
this
do.
segment,
We do.
but basically, to the extent that you put assets in the trust during your lifetime, or that they automatically transfer to the trust through a beneficiary designation or payable on death designation at the time of your death, then those assets within the trust avoid probate. So that's another tool that we use with clients who are hyper-focused or very focused on avoiding probate. We say, well, probably the best way for you to do that is to put it in a trust.
And currently, again, because of the estate tax environment, I don't see clients using trust as much as we used to, where that was how you played the avoidance of estate tax as best you could. But I do use trust currently for life situation needs. For instance, special needs children would require a trust. Clients who feel like their children aren't the most financially astute and they fear just dumping lump sums in them, we can hold that in trust. Also to react to situations, maybe the child is under addiction, whether it's drugs, alcohol, gambling, and they're like, I just can't leave them a big lump sum of money. The trust is an excellent way to hold assets for benefit of someone without just having them have the blank check and waste it.
Now, whenever I walk into your office and I look at the table where you sit in the conference room, I'm going to be looking for the MRI machine, because in order to properly understand your client, you have to put really almost like an MRI machine on their estate, on every facet of it, and there's so many wrinkles. Do you guys ever get caught by surprise as you are investigating and going through and pulling everything together, where something catches you completely off guard, like a deer in the headlights look? She's looking at me going, Bill, I don't know. I mean, do you ever get caught off guard by information? You get it all, and then all of a sudden you discover something else that...
I mean, I did have a client once that didn't tell me that they had children, and I said, well, we should probably mention your children, even if you don't want to make them beneficiaries of your estate. That's certainly something that surprised me. But I think there are things like under assets that people don't think to mention, especially a lot of people these days are having limited liability companies and how those get incorporated into the estate plan. That's certainly some of the things that I've been taken off guard.
I think, and for me, probably some of the stuff that stands out a little bit is just clients, they don't understand the gravity of a unique circumstance, probably the special needs aspect. So they either have a special needs child or grandchild, and we do the plan, and they'll say, I want to leave everything to the kids equally. You just can't leave certain assets to folks if they're qualified for certain programs due to special needs or other similar means. And so just they don't understand. And so when they say that to me, I'm like, the alarms go off. I'm like, well, we need to really plan for that. But I'm always glad when people ask questions, because the more we talk and the more we learn, as you mentioned, examining the estate, the better we can tailor it to them.
The more I'm listening to you, the more I realize what you do, you provide a service that is, people are not qualified to make these decisions on their own based on their own knowledge. They need an expert to oversee everything all at one time. So you put together a vehicle that gets them from here to there. We're going to come back in the third set. Patricia Niebauer and Bill Pate from Robbins May Rich are telling us or giving us information that we all need to know, regardless of our age or generation. It's a lot of stuff to digest. This is All Things Moore County. Welcome back to our third and final set of All Things Moore County. Interesting conversation with Patricia Niebauer and Bill Pate from Robbins May Rich. The estate planning basics are not easy to digest. There are a lot of steps to it, and so many people just have these misperceived notions about what it is, and I get a will done, and it's way more complicated than that. And I guess your job is to be leading the charge and to keep it simple and keep it in layman's terms so that people can understand. But it's a very intricate process if it's done properly.
It is. People don't realize how much their life circumstances drive what the documents look like. And again, every family is unique and they don't all have the same needs. I mean, I think we've seen wills where people are saying, I'm going to go to LegalZoom and just print something off the internet. And we've seen the bad effects of that where they don't have any guidance. There's nobody to explain the process and say, do you need a child who needs help? Do the siblings get along? Who should be the person in charge of the different processes? And so we highly recommend people talk with us or with an attorney of their choice.
Mm-hmm. One of the things I notice, the attorney of their choice, but I do notice there are certain attorneys who specialize in elder law. Do they work in tandem with you? How does that work, or do they do the same thing? Or I'm not clear what elder law is.
Yeah, it's interesting. A lot of times somebody will call me, asking about elder law, and this is really all they really need is what we have been talking about to date.
Okay.
You know, the powers of attorney, the healthcare power. Where the question for elder law really comes in is if somebody is fearful of running out of assets or trying to protect assets because they need an extended retirement or nursing home care. And there is a segment of law called elder law. It's very specialized, but those are attorneys who take your assets and basically attempt to legally change title to them or move them to help somebody qualify for Medicaid. And because what a lot of people get fearful of is, they may have just the family home left and they just hate to have to sell it or lose it, but they need to go into skilled care. There are techniques under elder law where people who practice in that area would be able to assist. It's basically a Medicaid planning practice when people ask for elder law and typically what they mean. But a lot of people do use them interchangeably, like I said, because I've had people come to me using that term, but they're not on the Medicaid planning aspect at all. They're just estate planning. But there is, yes, you are correct. If it's a Medicaid-focused qualification and potentially some asset protection for that, that would be elder care, elder law.
And Bill, to add to that, I've had a lot of clients, and many of us have probably heard of family members or friends who they lost the family land because grandmother or granddad had to go into a nursing home facility, and when they died, the government sold the land from under them, basically. And I've had a lot of clients come through and tell me, I don't want the government to take my assets. And there certainly is a place for elder law planning. What I tell people is that in order to protect the assets, the government, Medicaid, from taking those assets, you basically have to give them away and not have any ownership over them. And I don't know that that's the best advice to give to people, say, give away your house to your kids or gift away all your assets, because the alternative is you give it all away so that you go into a government approved facility. And that's not the best option, nor what most of our clients, I think, would want if they could otherwise potentially afford other situations.
Right. Have either of you come across a situation where a client will come to you and ask you about a reverse mortgage? We have, there are a lot of TV commercials and ads, and maybe some people who maybe are trying to get whatever equity they can out of the house. Does that ever come up?
I rarely have. I have never had anybody proactively ask me about it. I have dealt with them. We've had estates where somebody died with one in place and working through the process of paying off the remainder balance. But I haven't had anybody come proactively asking me for it as a technique.
Not really myself as well. I know clients of mine who have done that just because that's a way that, again, as their income dwindles and the cost of life is going up and up, it's getting harder for a lot of people on fixed income to afford the basics of life. So I know that's something that either is in place now for many folks or is probably going to increase.
So just like a doctor, you go in for an annual checkup. And what you were saying before earlier was every couple of years, maybe as life events change or finances change, a checkup is something that they should do once they have a plan in place.
It can be. What I tell most people is I don't hear from every single planning client every few years. But just please be mindful of major life changes. You will know if a close family member dies or you get an inheritance or something that majorly drastically changes your situation, and not forget to think that, oh my gosh, the person who was my executor or my beneficiary has now passed away, or my assets are quite substantially different than when I initially did this plan.
Right.
If nothing else, I try to encourage clients to be mindful of those things because typically that's what's going to require some updating potentially.
One of the things that I noticed when I looked at my revised will was that I was told that it is, because it was not a large document, there were other supporting documents behind it, was that I would have the ability to handwrite specific wishes that that has to do with either personal property. I mean, as long as it notarized, and that is considered legit, legal?
So under North Carolina law, you are entitled to do a handwritten list of your personal belongings.
Okay.
And so you can say, I want my ring to go to this person, the family Bible to go to that person, or this painting.
Okay.
And I don't know all the history behind that, but those wishes are so detailed that to put them all in a will and be revising them constantly can be quite cumbersome. So if people do have very specific wishes as to who they want to leave those items to, we encourage them to make a handwritten list.
And that is recognized. Does it have to be notarized?
It does not have to be notarized.
Okay.
And also along those lines, I encourage people, there's a lot of times where if you get too detailed or tie the hands of an executor, particularly a trustee, it can just sometimes get a little bit cumbersome. So a lot of times we may draft trustee discretion into trust or other documents, but I highly encourage clients, it's not going to be part of the document. But yes, if you have sort of things that are important to you or sort of guiding philosophies that you want to write down as a guide to this trustee that's going to be managing that account, absolutely I encourage it because it gives them much more feel for your intentions, even if we don't draft them all into the will. Sometimes if we get too specific in a trust for what the trustee can and can't do, it gets very, very cumbersome for them. But I encourage clients that anytime that they can let their intentions be known and make suggestions, especially as Patricia mentioned in the disposition of tangible property, it can definitely make things easy.
Yeah. Mina, is this more than you bargained for?
I'm glad I'm here. I don't have anything to add to it, but I'm learning a lot. So that's
Things
really
you hadn't thought about.
Absolutely. And I will be making an appointment at their office, and that's the truth. Your referral to me and knowing them is very valuable.
I remember turning 40, and I could spit into the wind, and it didn't bother. I did whatever I wanted to do. And all I did was at that time, I just got a will, and I just parked it. I put it away. I go, I'm done. How stupid. Life changes. So there's so many chapters to our books. Each decade we keep adding and adding. And I didn't have children, so I had one less thing to worry about. But I can see your head spinning listening to them.
There's a lot to digest. I think that it's daunting, and I think that's why getting in there and maybe them helping simplify this process, making it's not really as challenging as you might feel it is. They take care of obviously the nitty gritty, and if I can just get in there and bring them the stuff that they need, then they can do the hard work.
The truth of the matter is, it's a lot less painful than a root canal. It is. Yeah. No, it is. It's very organized and systematized, and as long as you're keeping your own spreadsheets and your Excel spreadsheets organized and up to date.
I don't have a single spreadsheet. I don't even know how to use them, Bill. And that's the truth. But I do have pretty good organized systems, but spreadsheets are not one of them.
I know we're getting close to time. I wanted to add one thing. There's one area that we do with a lot of clients that absolutely the intestacy North Carolina statutes have zero information about because they don't do it, and that's charitable planning. Charitable planning is very important to a lot of clients, and that's something that absolutely is not going to happen at all if you don't proactively plan for it. And so a lot of what we'll do is sometimes it's through the will you can do. Actually, qualified plans like IRAs and 401ks are extremely valuable vehicles to do charitable planning through. And so that's one aspect that when we meet with people that we're able to address, that nowhere in the North Carolina intestacy or anywhere else is that going to happen as a default. You have to make that happen.
Does it have to be in writing in the will?
Yes. I mean, you would have to either have a charitable clause in your will or have a charity as one of your designated beneficiaries under a life insurance or IRA. So yes.
My mother passed away in 2007, and I have 3 siblings. And we noticed in reading her will, she had a whole section on charities, and it might have been 10 of them. And she had next to each one a dollar amount earmarked. And that was all in the original document. And I walked away from that, never forgot that. Mm-hmm. That's not something you handwrite.
No. You can't really handwrite, I want X amount of money to go to a certain beneficiary. That's more, again, for the contents of your house. Okay. For those sentimental items that are not necessarily as valuable as giving an actual amount to somebody.
How can people reach both of you? Because I think we're at that point in the show where we have to thank you for coming, but we want to give out some information about.
Absolutely. We have a website. It's www.rmrattorneys.com, and the RMR is for Robbins May Rich. That's the name of our firm. Yep. And the phone number is 910-692-4900. And you feel free to ask for Patricia or myself, and either of us will be happy to meet with you.
So it's very simple, and then they can reach you through the website as well.
Correct. Yes.
Yes.
Yeah, I appreciate. I know how busy you guys are, but this is important. And Mino, I'm so glad you came because you represent many people in Moore County in the same age group that you're. I think you're right smack in the middle because the age is getting younger and younger and younger.
That's true. Thanks for having me, Bill. It's nice to be here and good to meet you guys.
Yeah, yes, I appreciate it. Patricia, it was a pleasure.
And thank you, Bill, for inviting us.
Absolutely, thank you.
It was a. When I have a thought, I have no filter. I just ask, and I wanted to, and I just thought it would be good timing. And we will make sure this is on podcast in a couple of days as well.
Thank you.
Fantastic.
Again.
Thank you both for coming.
Great. Thank you.
This is All Things Moore County. Have a great week.